If there was a warning label and you got hurt, it was obviously your fault. That's what a lot of people think. And in some cases, that's true. But the law actually doesn't look at it that way. And I want to explain today why. Welcome back, everyone. Attorney Craig Steger here, practicing in Wisconsin, Minnesota, and Iowa. It's been a little while since I live streamed. I'm actually live streaming to 3 different channels today: lacrosse lawyer, farming lawyer, and trucking lawyer. Because the thing I want to talk about today is actually very applicable to all 3 audiences. Okay, so let me set the stage for today's discussion. So I'm working on a case. I'm investigating a case where a farmer had his arm very seriously injured when it was pulled into a corn header that turned on. And I can't really provide a lot more details than that, other than he was lucky to be alive. And so I've been doing some research online and talking to people, trying to better understand the mechanics of how this happened and whether there was anything about the design of this combine or the header or the warnings or anything like that that may have contributed to this, or things that, let's say, could have been done that may have prevented this from happening. And as I started talking to people about this, almost everyone's response was, well, you're warned not to do that. You're not supposed to be in front of the header when it's running. There's all kinds of warning labels. It's obviously the farmer's fault. And I was a little surprised by that, in that I think if people better understood the situation, they might be a little more understanding of the farmer's situation. But it got me thinking that I think it's a really good time to talk about we call it products liability law. And every state is a little different. I'm going to kind of talk in general terms here, and I'll probably get into a little bit of specifics of Wisconsin, Minnesota, and Iowa. But it's really important to talk to an attorney in the state that you're in if you have questions about a product's liability situation. So with that in mind, let me kind of break it down for you. Essentially, there's 3 types of products liability claims or theories that can be brought, and these are based on a kind of an old theory of strict liability against manufacturers who produce or sell or whatever products that are unreasonably dangerous. And that in the unreasonably dangerous oftentimes is premised on the fact that there is a better, safer alternative that they chose not to use. And so products liability has a number of different prongs, but the 3 that I'm going to talk about today are this. Number 1, is there a design defect? Did they design it safely? And more importantly, did they rule out or refuse to use alternative designs that might be safer or less dangerous or whatever? So we call those design defects, and I'll talk a little more about that in a moment. Second of all, are manufacturing defects. So what's a manufacturing defect? A manufacturing defect is where the product, let's say, was designed okay, but the way that it was actually built or produced failed to meet up to those design specifications. A really good example is, let's say, a product is designed, but it doesn't get welded properly, or the fasteners don't attach correctly, and it fails because they didn't actually build it or produce it the way that it was supposed to. So we call that manufacturing defect. And the other third category is what we call warning defects. And a warning defect is maybe the warnings are misleading or confusing or don't really account for the foreseeable ways that a product can be used. And sometimes they have to foresee misuses of it, or let's say improper maintenance or repairs. Let's say guards that are on it that come with the machine have been taken off. The warning may need to accommodate and anticipate the reasonable uses of things, and build the warnings with those different situations in mind. And if they don't do so, that can be considered a defect in terms of the warning. So the three main types of defects are design defects, manufacturing defects, and warning defects. Now, this kind of gets to I want to talk a little bit about the whole question about warnings, because like I mentioned earlier, I think it's very common for people to think that, well, if there's a warning sticker or in the user manual, on the product itself, whatever the case may be, if there's a warning there and someone gets hurt, sort of in the way that the warning was telling them not to do, then it must be their fault. And in some cases, it can be their fault, but the law actually looks at it a little different. Let me walk you through the analysis. So generally speaking, and again, this will differ by states, but generally speaking, there's kind of a 3-step hierarchy of how manufacturers are to try to eliminate risks and hazards with products. So number 1 is to eliminate the hazard. Can we just get rid of the hazard entirely? An example that I'm thinking of is to design it so that there aren't any pinch points, or maybe if the design has a PTO, can we eliminate the PTO shaft, either moving it somewhere else or maybe going to a hydraulic system of some sort where you just don't have the inherent dangers of PTOs. So that is one way, is to simply eliminate the risk, eliminate the hazard by designing it in a different way. So that's what we call eliminating the hazard. And manufacturers are, generally speaking, required to do that if it's possible. Now, that is generally subject to it being reasonable and cost effective. So they don't necessarily have to do all things possible to eliminate hazards, but what is kind of reasonably practical without making the product just completely unusable, unworkable, or let's say cost prohibitive. So that's kind of the first step, is to eliminate the hazard if the hazard can be eliminated. Second step, sometimes even your best design, you can't eliminate the hazard entirely. It might still exist, but there may be ways that you can protect against it. So we're all pretty familiar with shields and plastic coverings and things like that. The PTO is probably the easiest example. So PTO shafts, it's not possible to eliminate PTOs from all equipment, farm equipment, construction equipment, things like that. And so when you have to have a PTO, probably one of the most notable things that manufacturers do is they put a shield or a guard over it, with those plastic things that slide around a PTO shaft. That's what we call guarding, right? That greatly reduces the risk associated with PTOs, but it doesn't eliminate them. But it is obviously far safer than just having an unprotected PTO just spinning around, because if you've been around farming at all, you understand the hazards and the dangers of PTOs and how quickly they can grab onto something and seriously injure or kill someone. So that's the guarding side of things. So the manufacturer is first required to eliminate the hazard if it can be eliminated, and then guard against those hazards that can't fully be eliminated. And then third step is to warn against those hazards. So this is really important to understand. A warning is really only a defense to the manufacturer if they have already accomplished steps 1 and 2. They've designed out foreseeable hazards, and they've guarded against those that can't be designed, and then they place warnings on whatever is left over. It's not enough that a manufacturer just slip a warning label onto a product, they first have to be able to show that they've designed, out any hazards and that they've guarded against them. And then they're allowed to warn. And then you get into question, is the warning adequate? Is it misleading? I'll give you an example. So actually, it's a good example of something that kind of goes through all three steps. So I have a case involving a gentleman who fell off of a tree stand that broke. And so, first of all, design. As far as we know, there's nothing wrong with the design itself. Tree stands are sort of inherently dangerous because you're literally climbing up trees, right? We don't require manufacturers to build elevators or stairs or whatever, right? So there's a certain element of danger remaining in those kinds of things. And then the question is, well, do they manufacture it correctly? Well, this particular case involves one that broke. One of the steps broke, and it was actually subject to a recall. Most likely, they didn't weld it correctly. So that would be a manufacturing defect. If they'd have welded it the way that it was designed, it probably wouldn't have broke. So, but because they didn't, that is a manufacturing defect. Well, one of the things the manufacturers like to point to is, well, you got to be wearing a safety harness when you climb these things. Well, the problem is it may not be possible, and in fact, may actually make it more dangerous to be using a harness and trying to adjust it as you climb things. So sometimes warnings either aren't practical or actually make things more dangerous. And so that's why sometimes you get into litigation or lawsuits about the warning itself and is it adequate. So that's kind of how the law treats things. But the one really important thing I want to emphasize is this. A warning does not protect the manufacturer from failures to properly design and properly manufacture the product. So even if someone has been injured or killed by, let's say, ignoring or avoiding a warning label or something like that, that does not mean that there isn't a case. It doesn't automatically mean that that person is at fault or the manufacturer isn't also at fault. It's really, really important that they talk to an attorney and get some, have the case evaluated. And maybe there is an alternative design. Maybe there was a safer way to do it. Maybe they knew about it. Some examples that I think kind of help illustrate this a little bit. Let's talk about chemicals, right? So sometimes you can make things safer by using a less toxic or less corrosive or less flammable chemical, right? So that might be a way of designing out the hazard, going from a toxic chemical to, let's say, a water-based chemical might be a way to eliminate or reduce a hazard through design. Sometimes you can't do that. It's still going to have a certain level of toxicity. So what do? You try to guard against it. So that's where the packaging becomes important. Is it spill proof? Is it liable to splash out in your face when you open the cap? So how is the cap designed? How is the, however it pours out, how is that designed? How is it being used and applied? Those kinds of things. And then finally, warnings. Are the warning labels adequate? What do they tell people to do in terms of maybe safety glasses, respiration, gloves, things like that? Those are all things that go into the analysis of whether the manufacturer has done their due diligence, has complied with their duty to try to make the product as safe as possible for the foreseeable user. So I hope that's helpful. There's other examples too of, especially in farming, you've got, PTOs, if you're dealing with, let's say, loaders, skid steers, loader tractors, headers, things that, lift up hydraulically. Do they have lockouts? Do they have a way to hold them up and when people have to do foreseeable maintenance on them. If not, that might be a design defect, because you can say do not crawl under a piece of equipment while it's suspended, but it may be the only way that you can do maintenance. And so if it's foreseeable that people will crawl under things or put themselves in pinch point areas, things like that, a warning may not be enough. You may need to provide guards or protections, lockout devices, things like that. Example I was thinking about when I was getting my commercial driver's license and going through trucking school. One of the things that we do is do a pre-trip inspection. And that's where you kind of go around, you start in the inside the truck, and you check all your gauges, your lights, things like that. You check to make sure that the air system is working properly. And then you go out and you check the engine, check the oil, check coolant, things like that. Well, one of the things that you have to do is to open the hood up on the semi, and the hood is a pretty big thing. And the hood is also very prone to shutting suddenly if a gust of wind comes up. And if you're in there, you have to be in there. You can't check the oil except in the engine compartment. You don't want the hood of that truck slamming down on you. And so the one that we used had a safety latch. So when you opened it up, it stayed open until you actually went over and released it. It's kind of annoying, but it has a very specific safety protection for truckers who are doing the normal foreseeable maintenance on their vehicles. So that's kind of an example. Those are sort of some examples in the trucking world as well. So I hope that's helpful. I have a Substack article that will be coming out as well. That'll have, I'd say, more detail and probably more specifics. If people want to access that, I really encourage people to go check out my Substacks on these things and subscribe to those. Then when I post new things, you'll get notice of that. If you haven't already subscribed, please subscribe to my YouTube channel. And if you have any questions or comments about anything that I've said in the video, or things that I left out or confusing, just leave me a comment. I'll do my best to answer those questions for you, either in the comments or maybe in another video, if that's a better way. And then finally, if you do need to talk to me or another lawyer about a specific legal case, don't talk about it in the comments. Just go down to the description. My contact information's there. Email me, call, text me, whatever. I'll be happy to have a confidential, free conversation with you and see if I can help you. And if I can't, maybe someone else can, and I can point you in the right direction. So I hope that was helpful. I really appreciate everyone for watching this. And until next time, everyone, have a good one.